everyone, to episode 5 of Decoding Appeals, Lessons Learned from Oral Argument. Today, we're going to be talking about the various aspects of oral argument at the appellate level, things like preparation, things like overall considerations, and the mechanics of how oral arguments go at the appellate stage. My name is Rob Szyba. I'm a partner in Seyfarth's New York City office. My focus is primarily labor and employment, handling cases at the trial level, at the appellate level, and beyond. Today, I'm joined by my colleague, Matt Catalano. Matt?
Hello, and my name is Matt Catalano. I'm a partner in the litigation group at Seyfarth Shaw, also in New York City, where I focus on commercial litigation and other disputes that are not in labor and employment. And I'm admitted in New York and Washington states, and it's very interesting. The appellate practice is very different in both of those states because in New York, they allow for interlocutory appeals, meaning that every order, even if it's not final, gets appealed. And so most of my appellate experience is in New York State Court, though I have also done Washington State and federal appeals as well.
So, Matt, between my labor employment focus and your everything else, we pretty much have the litigation and appellate ground covered, huh?
That's exactly right. That's exactly right.
So, Matt, let's talk a little bit about appeals and really oral arguments. I mean, first of all, do we even need to have an oral argument at the appellate level? What are your thoughts on that?
Yeah, it's an interesting question because as lawyers, we always want to have the last word, right? And we always want to do more. But sometimes the answer is honestly no. You don't want to have an oral argument. If the court orders oral argument, there's nothing you can do. But in New York State courts, at least, it's fairly common for parties to submit without oral argument, and that you'll show up on the day of an oral argument and you'll see a big punch list of all these cases that's listed on the cattle call, and then one after another, many of them will say this one's submitted without oral argument, so let the clerk know in advance or what have you. And that can be the right move if you are looking at a case that the issues are straightforward, you're looking at a case where the dollar amount in dispute is not worth the amount of time it would take to prepare an oral argument. And so there's a number of reasons why you might do that. And if you are in a case, though, where it's a big decision, where it's a final decision. So, for example, I'm in one appeal in New York State where we're appealing the loss of a bench trial, right, where prior counsel had lost at a bench trial, and it's a very, very big amount of dispute. That one, you definitely want an oral argument because there's a lot of issues to get through, and you want to be able to explain it to the judge. If it's just a motion and the judges don't want to hear it, and you're at an interlocutory appeal, maybe not. I don't know if you have thoughts on that as well, Rob.
Well, I think you're right that there's sort of this conventional wisdom that, as you said, you want to have the last word, or from my perspective, you don't want to miss any opportunity to have a presentation, to have to get your arguments in, to get something before the court. So you have this sort of natural tendency to want to say yes to just any opportunity, including oral argument. And I think you really need to think about it at the appellate stage in a way where, is it worth it? Is having that oral argument, investing that time, investing the time in preparation and preparing the argument and doing the argument, the amount of money that's spent to do it right is a time-consuming and laborious process. Is it really worth it? In cases where the issues are straightforward, in cases where the briefing has already done a great job as to explaining the party's position, it's a non-controversial issue perhaps, those are the type of considerations that might militate against having oral argument, because I think we've all had these cases where you're on a side where the court below got it right or dead wrong, and it's relatively obvious. Is there a benefit to going before a panel of judges who are inherently busy, have X amount of dozens of cases that they're deciding? They don't need to hear any more about this. And I mean, the flip side is if they do, they will have oral argument. They will schedule it whether you like it or not. But if there's no real benefit to having the oral argument, maybe there's a good reason to not do so. I remember I had a case recently where the issues were so straightforward that we had this exact same conversation and said, maybe this one we really don't need to seek oral argument. And the other side, who to their credit, called us up at some point and said, we don't really want oral argument. What do you think? And we said, yeah, we don't either. In that case, the decision came quickly. It was one of the shortest appellate decisions I think I've ever seen, and it was basically, the court below got it exactly right. We're all set here. So I think thinking through those issues a bit and kind of working through that systematically, there's a tremendous benefit to doing that. So if you can avoid the oral argument and get the result that you're looking for anyway, it's win-win.
No, absolutely. And I've also had that experience of submitting it without oral argument and then getting an appellate win. And so it's a little bit of a misconception that you need to have oral argument to convince the judges they're going to rule one way or the other, even if there isn't an oral argument. And so that said, we are here to discuss oral argument. So you have an oral argument on the calendar. Okay, so what do you do? What's your next step?
Well, in terms of preparing for an oral argument, I think, one of the first things that I like to pay attention to is any particularities or quirks that this court has, any formalities. What are the sort of unspoken things about this court, especially if it's a court I'm appearing before for the first time. I want to know, for example, as you kind of mentioned, is there a sheet at the side of the door that tells you what order the appeals are being heard in, or is there some other process? And I think, early on, when the case is first appealed, when it's getting briefed, a lot of these things, like in a lot of the circuit courts, you get a case manager, you can ask, these kind of questions. Sometimes your appellate printers have great insights into what goes on day of. And I think knowing those things, first of all, puts you, at ease, knowing that, knowing what you're getting into day of. As you step into the courtroom, what do you do? Where do you go? Where do you sit? What are those little formalities? And I think the other thing is, it really, once you have a handle on that, it really lets you focus on the substance of your argument or what you're really there to do, and not worry about, what are the little customs that the court might have. One of the comments I know in preparing for this conversation that you mentioned was watching videos of oral arguments in that court from prior cases. Tell us about that a little bit.
Yeah, so when I had to go before the New York State Second Department Appellate Court to do an oral argument, a quick Google search away, and you can see an entire archive of videos. You can see the judges that are assigned to your panel, or just the gist of how does this go and what are the times, and for example, in that court, they don't allow for rebuttal. And that was useful to know, because you might find yourself preparing to say, okay, and then I'm going to reserve my time and then I'll come back. Well, no, in that court, they actually don't allow rebuttal. And when you watch the videos, you see nobody comes back for rebuttal. And you learn, well, okay, I need to anticipate what the other side's going to say when I'm the appellant, because I'm not going to get a chance to do a rebuttal. And that's unusual. And in most other courts that I've seen in appellate courts, they do allow you to reserve some time for rebuttal. So even if there's no video, maybe there's audio, or if there's not that, I mean, every state has its own appellate courts. I can't speak to it. Certainly, as you mentioned, talk to someone who's been there, whether that's your colleague, whether that's the appellate printer, someone who's seen it, or just show up and see for yourself if it's a very significant oral argument. You can go to an earlier date and see how it all goes, in live and in person.
I think that's a great idea, and I think the example you give of rebuttal time is huge. I mean, that is a huge nuance in those courts that don't allow for rebuttal time. Another question that comes up a lot is mooting the argument. for me personally, I find that to be a critical step of really refining the argument for presentation. Things might sound, I mean, maybe this is a me problem, but things might sound great in my head sometimes. And, in my head, it's the most brilliant, eloquent argument that I'd ever want to make. But when you're actually on your feet being asked the question, it sometimes doesn't come out that way. And I think the moot process is a critical tool, both to get feedback from people who ideally are not super familiar with the case, so they have the fresh eyes that they're approaching the questions with, and two, for you to have the opportunity to articulate what you're trying to say and revise it. I think that's the critical thing, is that you get out the things that are happening in your head and then have an opportunity to edit and fine tune them, which I think is a fantastic opportunity. What about you? What are your thoughts on moot?
No, I think it's so valuable. Sometimes you're so in the weeds. Okay, these are the problems that I need to overcome. These are the very, very complicated cases, because you did all this research and drafting, and that, well, this I really need to focus on. But maybe someone coming into it fresh when you're mooting will say, actually, let's take a step back. I'm going to ask you a question that to your eyes is much more basic, because you've been living and breathing this case for so long. And to a judge might say, well, this is actually what I think is very important. And so to that end, it's valuable when you're mooting to have the associate who did a lot of research and drafting on that mooting panel, so they can ask you those pointed questions. But it can also be very useful to pull in a partner who has done a lot of oral arguments and knows the court well and has read the briefs fresh and is going to be able to replicate the judge's mind, because they only have the briefs and the record and not all those internal emails and internal back and forth and agonizing over the nuances of cases. And they'll be able to say, well, okay, I have a question for you, and it'll be something that you didn't even think about.
And on top of that, I think the other thing that the fresh eyes give you a little bit better of a perspective on is the bigger picture that this case fits into. You're talking about spending all this time living with the case and living in the weeds on these issues. You're presenting this to, circuit court judges or appellate judges that are setting policy for a region, a state, a section of a state, whatever, a state, maybe even the U.S. Supreme Court for an entire country. There are considerations that are going to be in the minds of these judges that are not in the weeds. How does this impact the bigger picture? How does this impact the policy of the jurisdiction or the state or whatever the case may be? And I think those are the kind of big picture considerations that you necessarily have to have in your mind as you're honing your argument. Because, we've all had those cases that your argument may be great technically, but in the big picture of the policy of the state just doesn't fit, and no judge is going to say otherwise. And you really need to figure out how to work around that or address it somehow. One of the things too that kind of in my mind when preparing for oral arguments is how to prepare for the unexpected. And it happens. I think we've all had oral arguments where something happens, you're like, oh man, I wish I thought of that. But I think the reality, at least, for me, is the more thorough your preparation, the more that you can check off these individual items. The practices, the customs, do they do rebuttal time? Do they have these quirks? You've mooted the case. You've fine-tuned these arguments. After a while, you've at least, for me, you internalize what it is that you're arguing to such an extent that the unexpected is navigable. What are your thoughts on that, Matt?
No, I agree. Yes, you could over prepare, but don't worry about that as much as under preparing. You want to prepare, know the cases, know the facts. You might get, you might start launching into the facts and the court says, I don't want to hear it. I'm more interested in this, that, and the other. That's fine. But you would rather be in that position and be prepared to speak to whatever the court wants to hear while getting your points across than be in a position where the court says, what about this case that was in the briefing, and your mind draws a blank.
Right. What about day of, Matt? What are your thoughts on, we've talked a lot about preparation, but what about day of? What are your tips or tricks or, pointers for day of our oral argument?
Yeah, well, get there early, know where you're going, what you're doing, and make sure that, as you said, you know the customs of the court. You need to check in at a desk, etc. You should have all that in your mind before you get there, especially if it's your first time at this court. When it's your time to go, take a breath, go to the podium, have what you're going to have with you, which I don't think needs to be extensive, but maybe at least the bullet points so you don't forget. Have your opening statement at the ready. You might get cut off, but you should be at least be able to be prepared to say what's your theme of the case, what's the few roadmap things that you want to get in front of the court so that the court knows this is what you intend to speak about, and be ready for the judges to say, okay, but I want to know about this, and be prepared to speak to that, answer the question that's asked, and then get back to your point. Don't certainly you do not want to talk over the judges. The judges can interrupt you, you can't interrupt them. But at the same time, if you feel like it's going off track, once you've answered the question that's asked, see if you can navigate it back onto the track so that the judges aren't overlooking what you think is the most important thing.
And it's interesting because something you just said kind of got me thinking a little bit. One of the things that I strive for, day of at the podium, is minimalism, is having the least amount of things floating around, paper, binders, all these different things. I want to be at a point where I am locked into that oral argument, so it's just me and the judges, and we're having a conversation or an explanation or a dialogue or what have you, but so that a lot of these things fall away. So a lot of times, my practice tends to be to minimalize as much as possible so there's not a ton of stuff floating around, have the bare necessities, and then really be able to connect with with the bench and address whatever they're asking, and not be so stuck in my head juggling papers and stuff all over the place, so that we can really have that dialogue. And on the point of that dialogue, one of the things that you have to deal with as an appellate lawyer a lot of times is the hot bench, the idea of getting mercilessly grilled with questions, and all the hard questions, of course, to the point where it's painful. What are your thoughts on that, Matt? I mean, we've all kind of gone through it, but what are your thoughts on how to manage a hot bench?
Yeah, so take a breath, right?
Maybe I should have said survive a hot bench, not just manage a hot bench.
Exactly. And it doesn't mean that you've lost the case, right? I mean, I think there is this mentality that, they're peppering you with questions, they're very skeptical of what I have to say, and maybe that's true, but maybe not, so don't give up just because or don't assume you've lost just because you're getting a hot bench. Take a breath, think about what's the question that's asked, answer that question. The last thing you want is for the judge to get annoyed with you because they think you're evading the question. And to that end, again, as lawyers, we want to always feel like we're in control. We know what's being asked. We know everything there is to know. But sometimes the judge's question will be incomprehensible or poorly worded. It's okay to ask, can you clarify that? This is a tip we give to people who are preparing to be deposed. If the lawyer is asking you a question and it's convoluted, we tell our clients, ask for clarity. Well, the same can be true when you're the lawyer and the judge is asking you a question. You can ask for clarity, don't do it too much, but it's better to think about it and answer the correct question correctly than answer what you think the question is, because you don't want to appear as though you don't know what you're talking about or you don't understand what the judge is saying, and then have the judge say, "Oh, Mr. Catalano, that's not what I asked," and so then it looks like you're being evasive, and that's the last thing you want. You want to be very direct. If the question is yes or no, right? If it's a yes or no question, you don't have to accept that premise, but you do have to at least lead with yes or no, because then it sounds like you're answering a question, and then you say yes and or yes but, and then you give your further explanation to the extent you can get it out without being cut off, rather than launch into your explanation and then it sounds like, well, I asked yes or no, what's the answer? And that you don't want to be in that position where you're being locked in, when often these questions are much more nuanced and can't be answered in a yes or no.
And it's interesting because at the risk of sounding overly idealistic, my approach is to assume positive intent. And what I mean by that is, in the context of an appeal, you might have a panel of judges who are struggling with big picture policy issues that are going to impact an entire state or entire jurisdiction's worth of case law. They're dealing with the pressures of that. They're dealing with a volume of appeals on sophisticated issues, because realistically, if they're easy issues, they're probably not spending a lot of time on appeal. It's really the complexities of these issues can be overwhelming. So getting questions and getting lots of questions from judges, the reason I say assume positive intent is because it really can be an opportunity to unravel something that might have been convoluted for the judge, might be something to kind of clarify a point that was getting lost or buried in the briefing, or whatever the case may be. And I think at the end of the day, if like my approach is to kind of err on the side of being a counselor to the court and someone that can help guide the court, help answer any questions, clarify any points, add any other additional context that the court might need to help the court with their decision, obviously, in favor of my position. But it really is kind of approaching it from that. And I think on some level, I think it helps me kind of maintain my demeanor with the court, as opposed to, getting nervous, getting flustered. Oh my God, I'm getting peppered with questions. And I think I'm off the rails with this kind of argument. I think it kind of helps keep my head clear and decluttered of all those kind of worries. And I think, kind of the hot bench, the flip side being the cold bench, as we're saying about all the things, say this, don't say this, and keep all these things in mind. The flip side is sometimes you get judges that don't have any questions, that sit back and look for your presentation. And I think in those instances, you make the points that you have to make. You've already briefed the issue. You've added, by way of your oral argument, some additional points or highlighted some issues for the court. I think that there's no shame in sitting down when you've made your points and the judges are satisfied with what you've said. You kind of said something earlier when we were preparing for today, Matt, about when you're getting hammered with questions with the hot bench and your adversary is not, or vice versa. And I think that's a really funny dynamic to have to deal with on the spot.
No, it's so true. And it's the flip side, or the continuation of our prior discussion about, well, do you even need oral argument? Can you submit without oral argument? Again, we have this instinct as attorneys that we need to get the last word in. We need to tell them more. If it's a cold bench, and on the Supreme Court of the United States, Justice Thomas famously very, very rarely asks questions to the point where it can make headlines.
It was like a decade.
Yeah.
Questions, wasn't it, at some point?
Yeah, it can make, there will be a headline that says, Justice Thomas asks a question, an oral argument. This is shocking. I have seen articles like that. Right. And so sometimes it means nothing to how your case is going to be heard, because sometimes that's just the disposition of the judge that's hearing the case. And you can't assume that because you're getting a cold bench, they're going to agree with you or disagree with you. Sometimes you can tell from the judge's demeanor that the other side got a very hot bench that was dripping with skepticism, and you're getting a very cold bench or very softball questions. And that's when you say what you have to say or what you plan to say, I suppose. But further to your point, if you're winning and you can tell from the demeanor, sometimes it's better to just rest on your briefs and say, okay, well, if nothing further, your honors, I will rest on the briefs, or however you want to end it, and sit down. And that can be the right strategy, and that is almost a matter of instinct and reading people and coming to an understanding. If there's a point that you really feel you have to make, that you don't think the justices understand, especially if if you're going second and they had all of their questions and you can tell that they're on the wrong path, you can make the points you want to make and don't be afraid to do so. But if it's a matter of I'm about to win this, or you get that sense and it's your gut instinct, and it can be strategic to keep it very, very minimal and just sit down when you're ready to sit down, and not take all the time that's allotted. If you're allotted 15 minutes and you only go 5 minutes and that's it, the justices aren't going to say, where's the rest of the 10 minutes? They're not, okay? They're very, very happy that you're done because they have a very busy docket in front of them.
Matt, it's been a ton of fun having this conversation with you today. Thanks for joining us and for participating in this discussion. To the listeners at home, thanks for tuning in and spending a little time with us talking about oral arguments. With that, thank you so much, and we look forward to seeing you at the next episode. Thanks, everyone.
Thank you.